Let's just jump right in, because if you're watching this explainer right now, you're probably dealing with one of the absolute most stressful things a worker can face: missing your hard-earned money. Look, protecting your rights is absolutely critical, and understanding how this system actually works is going to be your very first line of defense.
Seriously, is there anything more frustrating? You put in the grueling hours, you do the work, and then, bam, the sheer financial panic of a withheld paycheck hits you. Whether it's a final paycheck that never showed up, unpaid overtime, or being paid under the legal minimum wage, it just leaves you in a super vulnerable spot. But here's the good news. You are definitely not powerless here.
Today, we are going to unpack exactly how you can fight back. We're taking what feels like this giant, complicated administrative maze and turning it into a clear, totally actionable path to recover your unpaid wages. And we'll do this even if you are a complete beginner when it comes to the Tennessee legal system.
So, here's our game plan for today. We'll start with Tennessee wage law basics, then look at eligibility and necessary documents, walk step by step through the filing process, explore federal and civil alternatives, point out some legal resources and support, and wrap it all up with a summary and an important disclaimer.
Okay, Section 1. Tennessee Wage Law Basics, Knowing the Rules. We really need to look at a major gotcha that you've got to understand right out of the gate, well before you even think about taking your boss to court.
The big foundational law here is the Tennessee Wage Regulation Act, or the TWRA. Under this act, it's actually a Class B misdemeanor for an employer to violate wage laws. That means they can literally face criminal prosecution and some pretty stiff fines. It sounds incredibly powerful, right? Well, hold on, because there's a very specific limitation on how you, as the employee, can actually use it.
So there was this legal precedent set in a case called Abadir v. Tyson Foods, which established that the TWRA does not provide a general private right of action. What does that mean in plain English? Basically, if your boss shorts your check, you can't just go hire a lawyer and sue them the very next day under this specific act. Instead, your main route for holding them accountable is going through the state, specifically the Tennessee Department of Labor and Workforce Development. They're the ones who have the authority to step in, investigate, and penalize the employer on your behalf.
And that brings us to a pretty crucial crossroad: state versus federal options. While the state law generally blocks you from filing direct lawsuits for everyday violations, the Federal Fair Labor Standards Act, or FLSA, operates a whole lot differently. If your claim involves minimum wage violations or unpaid overtime, federal law actually lets you bypass the state board entirely and sue your employer directly in court. Pretty big difference, right?
Moving right along to Section 2, eligibility and necessary documents, getting ready to file. Now, before you rush off to file a complaint with the state, we need to make sure you're actually eligible and have all your evidence properly organized. Preparation here is literally everything. This piece of the law right here is a totally crucial, actionable tip. If you were fired, or even if you just quit, you must wait exactly 21 days after your separation date, or until your next regular payday, whichever one of those is later. You have to wait out that clock before the state will even accept your final paycheck complaint. Seriously, if you try to file on day 15, they're just going to reject it. Patience is quite literally legally required here.
But while you're waiting out those 21 days, it's time to play detective. Whatever you do, do not rage delete your emails. You need to document absolutely everything. We're talking personal logs of your hours, copies of your old pay stubs, your written employment contract if you happen to have one, and definitely any saved texts or emails where management talks about your compensation. This paper trail is exactly what state investigators are going to rely on to prove your claim.
All right, Section 3, step-by-step filing process, taking action. Let's get into the most practical part of this explainer and figure out exactly how to navigate the state system once your evidence is ready and you've waited out that mandatory time frame.
This step-by-step workflow is completely mandatory. Step 1. You can just file your initial complaint online through the state's web portal or call their labor standards unit directly. Step 2, the system generates a formal statement of wage claim form that includes your assigned inspector's contact info. But listen close to Step 3 because it's a trap a lot of people fall into. Your investigation will not legally begin until you physically sign and return that specific form. So many claims just die right there in the inbox. Do not skip that step. Now, be aware of this incredibly frustrating little obstacle, the number 5. The Tennessee Department of Labor will not investigate any claims where the employer has fewer than 5 employees. It's a super common trap. So if you work for a tiny mom-and-pop shop that only has 3 employees, the state agency is just going to refer you away. In that case, you'd have to pivot and look at your federal or civil court options instead.
Which leads us perfectly into Section 4, Federal and Civil Alternatives, when state paths aren't enough. Let's explore those exact alternative routes, just in case the state board isn't the right fit for your specific issue or, if you happen to run out of time.
And speaking of time is absolutely of the essence here. You got to pick the right lane before the clock runs out. For a standard state administrative claim, you only have 1 year from the date the wages were due. But if you have a federal FLSA claim for something like unpaid overtime, you actually get 2 to 3 years. And remarkably, if you have a written contract or an employee handbook promising things like accrued PTO or commissions, filing a civil action for breach of contract gives you a whopping 6 years to make your move.
So what actually happens if you win? Well, you might not just be limited to the original wages you lost. If an employer knowingly violates Tennessee wage laws, they could be on the hook for triple damages. Triple! And under the federal FLSA, you might win liquidated damages, which effectively doubles what you're owed. Plus, the courts can even order your boss to pay your attorney's fees and all your court costs.
Now, there is one major statutory loophole we kind of hinted at earlier. Remember how the general state law blocks most direct lawsuits? Well, this specific legal path exists for one very distinct scenario. If your employer misses that 21-day window for your final paycheck, you actually can bypass the state board completely. You can take your boss directly to civil court to recover those unpaid wages along with reasonable attorney's fees. It's a real game changer for final paychecks.
Okay, Section 5, Legal Resources and Support. Getting help. Look, filing claims and threatening lawsuits can feel incredibly daunting, but you definitely don't have to navigate these murky legal waters all by yourself.
Especially if you're feeling intimidated or worried about retaliation from your boss, know that there are some amazing organizations across Tennessee dedicated to providing pro bono legal aid. From the Legal Aid Society of Middle Tennessee and the Cumberlands, to West Tennessee Legal Services out in Memphis, to the ACLU of Tennessee. If you can't afford a pricey attorney, these folks exist specifically to make sure your rights are protected no matter what your bank account looks like.
Finally, Section 6, Summary and Important Disclaimer. Final thoughts. Let's quickly wrap up everything we've talked about and consolidate these actionable insights into what you really need to take away from this explainer.
The big takeaways here are actually pretty simple. First, preserve your evidence because rock-solid documentation is what wins cases. Second, respect the waiting periods, especially that strict 21-day rule for final paychecks. And lastly, act swiftly before your 1-year statute of limitations for a state claim totally expires. Don't let the clock run out on your own money.
Now, for a very important disclaimer. Because every single employment situation is uniquely nuanced, please keep in mind that the information presented in this explainer is purely for educational purposes and definitely should not be considered formal legal advice. You should always consult a qualified legal professional to get guidance tailored exactly to your specific case.
At the end of the day, knowing your rights is really only half the battle. The real question is, will you just let a missing paycheck slide, or will you take action today and use this knowledge to demand every single penny you've earned? Thanks for exploring this with me today. Stay empowered out there.